I'm Judge Dunn. Sorry about that cut off there for those of you who are at home. We've been doing this presentation for several years now. Hope to add a few new things in it. I see a lot of new faces here in the crowd live here, and we'll also deal with questions as they come up. The only thing I would caution you is I may not be able to answer every question, specifically if it's case specific. I'm the guardian of John Smith, and I want to tell you about John's matter. I can do some generic things, but matters that are in front of me, I'm barred by the Code of Judicial Conduct from commenting directly on those. So I'll also give you my card before you go. You're welcome to contact us with any questions at the court. We'll try to help you out all the way through. So what's the big importance of age 18? In law, 18 is the point in time where you can contract and you're responsible for your actions. People under the age of 18 are deemed to be incompetent for purposes of contracting and incompetent under the eyes of the law. That's why we have juvenile court, and that's what I do the other half of my day. All persons under age 18 are deemed to be disabled. 18 years or more who are under no legal disability are capable of contracting and can do everything that we all do as adults. We can enter into rental agreements, student loans, we can get credit cards, we can do everything that we foolishly do as adults and have to do. Also, we can access our bank accounts, we can cancel or refuse providers, including DD providers. So that's an interesting thing to be aware of. Also, you can make educational, employment decisions, medical and treatment decisions. The big concern is, what is a legal disability? Well, that is covered by a guardian. A guardian is a person or a group. We may have groups of corporations now acting as guardians over individuals who are appointed by the probate court to care for and manage the person or the estate of an individual, or both, of an incompetent individual who's known as a ward. Oftentimes, they're commented on as an individual under guardianship as well. We use the term ward just for purposes of brevity in our presentation, but you may see that presented to in documents, a person under a guardianship. What is incompetent under the law? So, a person who is so mentally impaired as a result of a mental or a physical illness or disability, as a result of intellectual disability, or as a result of chronic substance abuse, that the person is incapable of taking proper care of the person's self or property. That covers like 4 different areas. And what we do is, when we conduct a hearing on that, that's what we inquire on. Those are on your applications and your petitions to cover. Any one of those items can trigger a finding of necessity for a guardianship. The last one here of chronic substance abuse, that was a very popular item to have several years ago when the heroin epidemic was so popular. And I'm a member of the Probate Judge Association. I'm on the board there, and I speak regularly at different meetings. We get together, all 88 counties, and discuss these matters. I believe we've only had like maybe 4 or 5 people across the state take advantage of trying to argue that chronic substance abuse. And it's a real hard thing to do for a loved one or a parent to come forward, because they're putting a requirement that they have to also establish a basis that I'm going to pay for this, I have a treatment protocol set up for the individual, etc. And sometimes those things just fall apart. We have 2 different types of guardianship powers. As indicated, there's a guardian over the person, and there's also a guardian over the estate. The guardianship over the person protects the ward, the person under guardianship. They authorize medical professional care counseling. They also arrange placement. They make educational decisions. Sure, come on in. And they provide maintenance for the ward. That maintenance can be applying for getting Social Security disability. It can do all kinds of items to make sure there's an income source there. Also, guardianship over an estate, making their financial decisions. It's kind of crazy because we're one body, but the law looks at us almost in 2 different ways. My physical body, and then all my possessions and everything I own. So guardianship over an estate is usually not necessary if your primary income is just Social Security income, because you can designate someone as a payee. And that's something that you should be aware of. So co-guardians, I oftentimes, we present this, we have individuals that say, hey, we want to be co-guardians of my brother, my sister, my aunt, my uncle. Is that a good thing? It can be. It can also be a difficult item too. The one thing I tell everyone is that the probate court, and in my position as the judge, the court is deemed the superior guardian of everyone who's under a guardianship. That means the power of the court rules over whatever brothers, sisters, cousins, etc., who may be the guardian are. And for example, this weekend I was at Buckeye Boys State getting ready to gather up for the last day and come home, and I got 3 calls beginning at 4 o'clock in the morning on 3 different people that needed medical care. So 4 a.m., 5 a.m., and 6:20. I got calls saying, hey, we can't find the guardian for these people. They require some medical procedures that are life-threatening, and I had to step up in my position as superior guardian and make those decisions for them. So that's just something to fall back on. But I tell you this, as a guardian, we expect you to do your job, do what's best for the ward, and those powers as superior guardian, we don't like to pull those out every Monday, Tuesday, Wednesday. Those are kind of like superpowers that we want to try to keep and not have to break out. So these can also be limited. You can give limited powers of guardianship over individuals. Those can come about after the hearing. That may be to establish the guardianship. You may get an order that restricts what you can and cannot do as a guardian. It could be a specific power, create a special needs trust, a Medicaid payback trust. And if you're ever going to do those things, please get super competent counsel to do those for you. If you have a special needs trust, just don't hire Joe Smith who's on the back of the phone book or who's advertising on the internet. There's specialty law firms and specialty attorneys that work, strictly in these areas, and they're well worth the hefty investment to get those done. So, what do you do if you want to file a guardianship? Well, I'm going to tell you this. If you go to the Medina County Probate Juvenile Court website and you kind of start scrolling through, there's so much stuff on our website, it's almost daunting. At this point in time, we're in the process of redoing our website. Even we're going to add how-to YouTube videos on here's what we're looking at, here's what to expect when you come into a hearing, and all those things are in process right now. I wish I could say next year I hope to wow you with that and bring it out here for the seminar. But the application's filed in the probate court, which is on the 4th floor of the new court building at 225 East Washington Street in Medina. And right now, Medina is torn up, so good luck trying to make your way around the square because they're making a water line improvement. And I just gave a hard time to the mayor. I said, you guys usually wait till Fair Week to try to close all of Medina, but you're doing it now. So what happens when you file? Yes, ma'am. Yeah. Sure.
When should you start the process for filing for guardianship? If your child is turning 18, like in the next
You can
6 or 7 months,
you
do
can
you start
file
it
it
now?
early. You can file. The question was, can I file this early? My child is not 18 yet. That currently they're probably under your powers, and you're the parent. You have all that control. Now, hey, my child's turning 18. You can file it in advance. Our staff will pull that. We won't set a hearing until your child is 18. So that's how we try to get around that, so we can hop in there almost immediately at the age of 18. Congratulations, happy birthday, and welcome to the probate court for your guardianship hearing. Okay? And we try to get those items done. I talked about co-guardians and like a couple of slides ago, and the issue that sometimes we have with co-guardians is getting everybody on board. You can also always have that clash of, I want this, you want that, we can't come to an agreement. Also, you may have issues with banks, financial institutions. They may require both of you to be at a signing or show up and do items. It's not necessary, but how are you going to fight City Hall on those things? The banks don't really comprehend that, and oftentimes we issue orders on them, and they still don't get it. So I always say, hey, if you can have a successor guardian, brother's going to be the guardian, then sister will be the successor if something happens to brother, that works out quite well. Co-guardians do work for parents, however. Yes. Yes. Oh, they're gonna put you on the mic. Yep.
So so we're married,
Yes.
and if is it only one of us being
You
a
you
guardianship or
you can
a
apply as both, but I tell people it's based on the circumstances. You don't want to do co-guardians typically. Some of the issues that we have, let's see if I can get here, are I have a sister who lives in San Diego. I want to be co-guardian of mom too. Great, except I'm in the position of having to make all the runaround, all the calls and everything. And if I have a bank or a facility that says we require both your signatures, we're talking about the FedEx run or something like that. It's just a convenience factor. You need to sit down and have that discussion on how you're going to proceed and what would be best for you, what would be best for the ward. Make sure I got this thing switched around. I'm sure I did it backwards. But
There's a couple questions
yes,
online. This one is definitely along this line.
sure.
This one says, my 81-year-old mother is guardian of my stepsister. Is it possible for me to become a co-guardian while I live outside of the state of Ohio?
Typically, we like the guardians to be in the state, a resident of the state. We will make application for that, and under special circumstances, we're willing to grant that. It's a difficult matter to attend to when you have a ward or a person under guardianship in Ohio and you live in Colorado, because the time change. If mom needs to go in for medical treatment, who's there to authorize that? Who's there to do those things? So it's not a bad backup, but it's case by case that we would take a look at whether that's warranted under the circumstances.
And then this other question is, if you have financial debt, does it affect obtaining guardianship? And is this information, I'm thinking in this presentation, all the same for Akron residents?
The application would be basically the same. We're basically following the code, the Ohio Revised Code, and our applications in our court, which are applicable to other courts as well too. So the financial issue, that's one of the concerns that we have to look at. Is the person related to the person they're going to be the guardian of? If there are financial concerns, and we'll cover that later in the program, also physical concerns, criminal concerns. Can they get a bond through a probate bond, through a court that says, look, it's actually an insurance policy that says if I screw up, you can call the bond judge and that will pay back any monies that are missing from the ward's assets. So that's an application. Yes, ma'am. That's okay.
So you mentioned the successor guardian. So
Yes.
if we did mom as the guardian, dad as the successor, is there a limit? Like, could you also have a sibling as a...
This isn't indefinite. You'd have to come to court and ask for another guardian to be appointed. And we go through that process on a regular basis with the death of a guardian, or if a guardian may become incompetent or physically incapable of being able to take care of a ward. It is pretty consistent and pretty regular. It's not something that's rare in our line of work. It comes all the time. So one of the things you're going to fill out when you fill out your application, you had to fill out who are the next of kin. They have a spouse, who are known to reside in Ohio. Spouse, children, both parents, sibling. And these people would get notice that, hey, we're filing an application to place someone under guardianship. And those people can waive what we call service of notice, which is them signing some documents saying, hey, I waive, I understand what's going on here. Oftentimes we may have contested matters. A brother or sister may show up to court and say, I don't think mom needs a guardian. That's why everyone needs to be put on notice of it. It's amazing to think, but some people do try to take advantage of being guardians over individuals for financial reasons and property transfer reasons. Not typically here at DD board individuals, we don't usually have that, but it's kind of the elderly that get pushed around. So one of the things when you actually go through the application process, there's going to be a criminal background check. Conviction of a crime will not automatically disqualify someone from serving as a guardian. And if you're charged with or convicted of a crime involving theft, physical violence, sexual abuse, alcohol, or substance abuse, those are things that set our radar off. and we're probably not going to be very interested in having that person be in that position, just with the potential of abuse of someone who's can't take care of their own affairs. Other thing you have to have is what's known as a statement of an expert evaluation. You just can't come in off the street and say, hey, I want, my sister can't come in from San Diego and say, hey, I want Judge Dunn put under guardianship. No, she has to have a doctor, a clinical psychologist, sign an affidavit to that effect. And that original signed document has to be completely filled out. I tell you that because if you're taking a potential ward in, sometimes doctors just fill out one section or just check a box. We need the entire portion taken out. We also have, in certain situations, we have a clinical psychologist who will do the evaluation of an individual at the court. We also use that person in situations where there may be a contested guardianship to also give a second opinion for the court's edification. A hearing. Wow, we have to come to court for this? Yeah, and that can be daunting. It can be daunting on the potential ward. It can be daunting on the individuals petitioning the court. We can't file and go forward with the hearing before the 18th birthday, but we can do it as soon as they turn 18. So, okay. The court investigator, we have a court investigator, Nikki Shook is her name currently in my court. Every court has a court investigator. They go out and they serve the petition on the individual with whom you are trying to establish a guardianship for. That individual, hey, if my sister wanted to serve it on me, I get this packet. And Nikki Shook would come out, hand it to me, and say, Mr. Dunn, you're being served. There's an application going to have a guardianship established over you. I would have the right to have counsel and independent medical evaluation. We have a lot more individuals contesting the petitions that are being filed in the court, so we're doing that on a more regular basis. You can have resistance. I'm 18 now. I don't need a guardian over me. I'm not a baby anymore. We go through that process on a regular basis. We have some individuals who are capable of taking care of their affairs and in order, others not. That's why we have that independent medical evaluation done. We assign them attorneys and we pay for those attorneys through the court. So the ward, if they don't have resources, will always have the availability of having an attorney represent them. Obviously, if they have the resources to have their own attorney, that may be assessed against them by the court at a later point in time or be required to be paid for counsel. So we go into the hearing. You don't need to be represented if you're petitioning the court to be a guardian of someone. I can tell you 88 different counties, we're all going to tell people, get an attorney. Get an attorney. It's just best for you that does this type of work to walk in, to be able to present your evidence. Our court staff, our magistrates will do some inquiry on your behalf because ultimately our goal is to ensure what's in the best interest of an individual who's coming before our court. And in so doing, we may take the lead and make sure that all the statutory bases questions are asked and the items are, the I's are dotted and the T's are crossed, so to speak. So if you need accommodations, just in my court, call ahead. We have one court room that is completely flat because we've had individuals that there's no riser for the magistrate in it. And quite often the magistrate will walk out and talk to the individuals at the table, at their respective tables. We have walkways in so you don't have to coming up an elevator to the 4th floor. It's handicap accessible. But if there's any provisions that are necessary that we should be aware of, call in advance so we have those items and provisions set up for the hearings appropriately. Our hearings are all recorded, and we have a recording system that can subsequently be transcribed by a court reporter. So the proposed ward has the right to be present and have anyone there he or she wants. That can be daunting too. I want my friend to come. I want my boss from work to come. I want the Uber driver to come up. Well, we have to honor those requests. Now, those people may not be able to actively participate in the proceeding, but that's what the law says. We have to be open and provide that opportunity. So we have a hearing. We put all these items on. We hear the matter. And what are the requirements of a guardianship of a person only? What we make the scenario and we say, okay, we're going to name you to be the guardianship of Kevin Dunn, but only of his person. What do you have to do? Well, my sister would have to file a guardian's report with a statement of an expert evaluation. It says, Kevin Dunn needs a guardian because he has a lack of capacity, understanding, can't take care of himself, can't tend to his daily needs, can't bathe. You know, this is all written out by the doctor or that psychologist or mental health professional who has signed that evaluation. So that comes out. There may be a check box on that particular application saying the ward's condition is not subject to change. We may have an individual with a traumatic brain injury, something of that nature, so you don't have to go out and get that expert evaluation every year. So you may want to ask that of your evaluator, is this a type of diagnosis that this potential to change? Will the person get better? It's not like, and it's difficult because oftentimes you're not talking about a broken leg. You're talking about a long-term situation for someone. So what's the other thing that as soon as we get that evaluation in, you have to come up with this annual plan. This is set up for you, and you must come up and how am I going to take care of my ward? Or am I going to have housing for them? How am I looking to take care of their medical? And it's kind of a detailed bio of what you intend to do as and for in the position of being the guardian. So, guardian of the estate after a hearing. And if you're both, congratulations, you get to blend these two kind of together. But if I'm just looking to be the guardian of someone's estate, I have to file a thing called an inventory. And that's due within 3 months of you being appointed by our probate court. And the way the probate court appointment works is typically a magistrate may hear your application, say, I'm going to make a recommendation and issue an order, a magistrate's order, that a guardianship should occur on behalf of the applicant here, and they should be named the guardian. It then is routed to my desk for my review. The individual who is being tried to be placed under guardianship may object to the finding of the magistrate. They can file an appeal of my order, but typically those are routed, and we have an electronic system now that moves very quickly. That paperwork comes to my desk, I review it, I affix my signature, and boom, it's an order of the court. So we don't have this issue anymore of a couple of weeks going on and, hey, Judge Dunn, I've signed these orders when I've been in Europe. I can now do that, log in, and get those things done. So guardianship of an estate, you have an inventory. What does this person possess? Where are the accounts? What do they have? Amounts. You have to file a bond if ordered. If the circumstances are the person has significant assets, we will probably require a bond. Bonds are issued by insurance companies. It's a fiduciary's bond saying you will actively comply with everything that's asked of you. Some courts have dropped the ball on this. We try to be really on top of things. We'll notify the bond company that, hey, this person hasn't filed their inventory. Hey, they're not keeping up with their accountings, to trigger them to that, hey, there could be a problem here. And we'll bring that matter before the court using our powers to try to get that done. One thing you're going to get is an application to release funds. You may have to file, hey, I need to get monies out of this bank account to pay the facility where they're residing. You need to apply to the court to get those accomplished and expend the funds. Hey, if I need to pull this money out of the bank wants to see something from the court saying it's okay to pull these funds out of a restricted account. Then, hey, we're going to expend these funds by paying for rent, housing, food for the dog, whatever it may be. Our court will typically grant those matters if they're reasonable. We oftentimes will have guardians of minors. Sometimes parents will come in and they'll want to have monies to go on trips. Hey, I'd like to buy my kid a car. Well, your kid's 12 years old. You know, they're not driving. So we'll have some hearings on some of those matters. But we typically will grant those in most cases if the expense request is reasonable. And then every year we want an annual account. Here's what we came in with, here's what's left, here's how we spent the money, kind of like a checkbook. I would also tell you that's not included in your packet is, as we go on to the next section, what will be required of you is we have training requirements. All guardians related to wards by blood or marriage are exempt from what's known as a 6-hour guardianship fundamentals training required by the Ohio Supreme Court. That's up to the discretion of myself and our court staff to determine, hey, this person needs this training or does not. If you're unrelated to the person, you're required to do a 6-hour training program. And initially when the Supreme Court rolled these things out, they were making everyone drive to Columbus for that. So we had utter outrage from individuals whom had raised their children, who may have been developmentally delayed, and you're going to make me drive down to Columbus to tell me I can raise my child and take care of them. So we made exemptions in that part of the statute ourselves and took care of that. So the other thing we have is guardians who are related by blood or marriage. We have a local training class in lieu of the 6-hour class. That's put on by our staff. It's typically held up by the court. If you're managing assets through the guardianship, you also have to take a 3-hour continuing education class each year as being the guardian. And yes, I see you pausing.
When will this local training class take place?
It's typically provided to you as soon as you file for your application for guardianship.
Okay.
So that will be part of your orders. Congratulations, you are the guardian now of Judge Dunn.
Okay.
You get to come to court and meet our staff, and we'll give you a training scenario on this. It could be done remotely. Our staff puts those items together and walks you through what's expected of the court.
Okay.
Okay?
Thank you.
So you're quite welcome. Some other courts will do those things differently. And if you want, we can forward this PowerPoint to any of you so you don't have to take copious notes, okay? I always hate that when I go to seminars that someone's pointing out stuff and I'd like the documents themselves. We'll provide it to you. The other item I would tell you is this is on our web page. This is made by the Ohio Judicial Conference on understanding your role as a guardian. It's a 20-page document. It walks through a lot of materials for you, and this is part of the issue when you do this training in Columbus that they provide. And it walks through how to do a guardian's account, what's a guardian, what are some of this terminology you'd look at. It's 20 pages. You can download it, print it off of our web page. It can help you out to give you a little bit more education in the area. The Ohio Judicial College is all of the judges in the state of Ohio working in conjunction with the Supreme Court. And we try to do our best to educate the Supreme Court in the areas of probate law, and sometimes that's a heavy lift because those people never practice probate law. But after you have your training, you're going to learn what we expect of you. So related by blood or marriage, the local training class in lieu of the 6-hour course. Assets, we have a 3-year course that they typically offer that online and make that available to you via Zoom. And I believe the Supreme Court is updating that as well. Typically that happens every year, so you don't get bored seeing the same presentation every year. So after the hearing, all decisions you make, once we appoint you to be the guardian, have to be in the best interest of the ward. And what you have to do is you have to take into account what the ward's wishes may be as well. That's a fact-by-fact case situation. Some wards are able to express items better than others. Some can't. Some you may have a ward who's nonverbal, and you have to make those choices that are in that individual's best interest. You have to monitor and coordinate all their services and benefits, including maintaining eligibility. We do have hearings on those quite a bit to remove people as guardians who drop the ball on that. I'm not going to follow up with that. Why don't you, we get the call, and how this typically happens is we'll get a call from a facility saying, hey, rent hasn't been paid for the bed. You got to get this person out of here. And we find out about it as superior guardian. We call the matter in for a hearing. My court investigator has to go out, track things down. I'm responsible for roughly 1,100 people under guardianship in Medina County currently, full-time. Then I have minors that fluctuate, and those things transfer out once those kids turn 18 and they run off with their money that was set aside and do some other things that way. But it's very important that maintaining the eligibility should be very preeminent in your services because that's one of the factors the court looks at, and that's what's kind of best for the potential ward. All guardians, all right, I hit the wrong button. Here we go. Okay, continuing reports. Well, if there's abuse, neglect, or exploitation occurring, this could be at a facility where a ward may be placed. If you have concerns, you owe an obligation to report that. Hey, the condition of the ward has improved. We've had situations like that. We had an individual who was diagnosed with what was thought to be a traumatic brain injury. And this person was basically in a coma, came out of that, came back, and actually, I believe last year, improved so much, the guardianship was relieved and came in the last time we saw the individuals getting a marriage license, which is kind of a thumbs up for the probate court. You have to notify us if the ward's died. What's important with that? Close the matter down. We want to make sure that monies aren't still being paid to people that is sitting out there, someone's cashing in on someone's benefits. If you change your residence, notify us in advance. We basically, as probate judges, get along very well, and I'll have matters that'll be transferred into Medina County from Summit County, Stark County, other counties saying, hey, the ward's moved here. Will you take their case and monitor it on your docket? Sure, because my staff's much easier to go down to any of the facilities and make sure that the ward's being taken care of than having someone come up from the Ohio River and try to manage that. So also notify us if you're going to move to a more restrictive setting or outside the county. That requires court approval. And give us a heads up on that so we can go out, have our investigator scout it out. She comes in and can provide testimony to the court, give a report, hey, we think this is beneficial for this ward. If no one objects, the ward's okay with it, we can grant those things fairly rapidly through the court. Or you also have a report if you are going to file a lawsuit. We need to be aware of that as well too, because individual who's incapacitated has to get the thumbs up that the guardian can bring an action on their behalf as well, because that's one of the powers you have as a guardian. That's one of that person can't swing their own sword, so you're going to be given that sword to swing for them, to protect them. Okay. Paid providers. This has become a very prevalent issue here in the last couple of years. So Ohio law provides it is a conflict of interest for a guardian to serve as a paid provider. However, they give us the authority as the judge. That's our threshold. Take a look at it, Judge. What do you think? And we have a lot of paid providers. If you make a request, an example I recall recently was individual with such special needs required pretty much around the clock. The person who was providing this was a parent. They said, we need to take some of their items to pay to support the household because I can't go out to work. I'd be switching one provider for myself doing it, and that's kind of a wasted effort. And ultimately, we hear those cases and we can do a case-by-case determination whether we think the paid provider would be acceptable. So don't give up on that. It's better to ask permission for the court and get that permission from the court than resolving it. Guardian cannot receive incentives or compensation from any direct service provider. That is an issue that sometimes creeps up. Hey, bring us your people and we'll slip you some of the monies back. That's actually occurred. We had that happen in a facility that's no longer in existence in Medina County. Hard to believe, but it's amazing what is out there in the world, I guess. So, do you need a guardianship? What are alternatives to guardianships? If the person's competent, You can do all kinds of great things. They can revoke their guardianship. They could agree to it and then revoke it, say I'm competent now. Uh, it's also voluntary. I've had people come and say, I'll give you a guardianship to get me in a facility. Some other items that we'll see are conservatorships. Conservatorships are merely, they operate like a guardianship. They have court supervision, no expert evaluation, so you don't need to have the person taken to a doctor or a psychologist or a mental health individual. There's no guardians reports or annual plans that need to be done. But what happens in conservatorships, these things typically terminate. Hey, I've broken my leg, I got in a bad car accident, I need someone to take care of my financial affairs for me, operate my business. And as soon as that person gets better, gets out of their rehab, if it's physical rehab, they come to the court and say, terminate the conservatorship, I don't need you anymore. So those things typically don't last on a permanent basis. Powers of attorney. Powers of attorney are a document that are very powerful. They are very dangerous, and they can open up the world of problems for you and also a world of great benefits. There's a healthcare power of attorney. Most of you have probably seen those. Every time you go into the doctor or the dentist, they ask, did you have a healthcare power of attorney? The state of Ohio used to have a standard form online you could use, and it's a little bit harder to dig and find. This makes decisions and a withholding of services in the event you were found to be in a terminal state. You can make an election on that. There's also a durable power of attorney. A durable power of attorney is a document that I sign and I give it. I'm going to turn over here and say, Nicole, I'm going to give you this durable power of attorney. You have the authority to do all these things on my behalf, and it exists even after I'm deemed to be found incompetent. So it keeps going on. It's a dangerous document because people who get these documents are acting in my place, or the person who's under guardianship, or the person who's under that power of attorney. They can go into a bank, they can sell property, they can do anything you can as a person. And the problem with that is it's just like anything else. You can either be Luke or you can be Darth Vader in making those choices as a power of attorney. So we have to ensure that those things are done. Also, a power of attorney can be revoked by an individual. I could go in, and that's a big hassle to do, and typically you have to file that. If there's real estate that a person may own, you have to file that revocation at the recorder's office to put the world on notice that that power of attorney that someone's walking around with is not valid anymore. We also have representative payees for Social Security income, someone who's representing to accept the benefits and apply them for the individual. Some individuals would do that to avoid having a guardianship, avoid having to go through the process, and sometimes that will work out depending on the circumstances of the individual who may be deemed to require those needs. Trusts, you probably have been inquiring of what's a trust. Would it benefit my potential ward? Would it benefit my child? Those are items that need to be reviewed with competent counsel, an attorney, as to what you can benefit. Is it a special needs trust? Is it a Medicaid payback trust? Is it just a living trust that a lot of people have for their items? And those were meant to basically circumvent the probate court, so you don't have to come to the probate court to get our approval for each and every asset you have to transfer upon your death. So we also look at alternatives to guardianship. Hey, we've had numerous cases that there's a great support system. Does the person have supported decision making? Can they make decisions? They have enough people there helping them guide them to the right location. And we will have those cases come before our court on a fairly normal basis. It's hard to believe, but we do have those. And where we see that happening is when the neighbors get together, because we have a little old lady on our block that's, her family's left her. But she's capable. If we all get together and talk to her on some of these things, do we really need to have an application filed? Does someone need to come in as a guardian over that person? Or can we work with the person? And does the church, do we have all these things that are willing to work with the person, make sure they're fed, clothed, all the stuff that basically imposing a guardianship responsibilities in the neighborhood over an individual versus having a formal person. Yes, ma'am. No, yeah, we got that pause going for me.
Can you have more than one of those alternatives to guardianship?
Yes, yes, you can. The question was, can I have more than one of those? Typically, you're not going to have a conservatorship and a guardian. You could have powers of attorney. Powers of attorney upon the guardianship go out the door. Okay, so that's one thing you should be aware they get chopped off. So if you have to go and have a guardianship established for them. Those are some of the items that we typically try to go through. And here's our contact information at the probate court. The other thing I'll tell you is if you are looking to go and file a guardianship application, we have different sections of our website saying guardian, guardian of a person, guardian of a state. It'll pop up. If you press those buttons, you'll see all these forms. All these forms are prepared by the Ohio Supreme Court, and we have a forms committee of judges that get together so that we can have similar type of applications court to court to court all through the state of Ohio. And we get together, and Judge Wiles, actually the judge in Wayne County, is now the head of that committee. So we get on her case, hey, we need a new form done up, or something's wrong in this form, can you change these forms? But you should go on, I would suggest, any of the court's websites. They will pop those forms up and give you an example of, hey, this is what an inventory application looks like. They're kind of barren because we don't give you an example one filled out. And currently we're in the process of trying to get those items updated on our website to be able to walk you through a little bit better. I suggest to people, if you have a complicated matter, always hire an attorney. They're worth their weight in gold, especially someone who practices in the elder law area and or guardianship law, a probate attorney who's familiar with this practice, a person who's doing special needs trusts. That's a real niche area, and you don't want to get someone who can screw up all the taxes. We see those coming out of injury cases quite a bit, wrongful death cases. Those things come in front of me as well. So everything that comes through the probate court is basically going to be stuffed in any other area of the Ohio Revised Code and doesn't go into other courts. So we're put in a position of making sure that every person who's under a guardianship is being taken care of by the court. I'm also in this capacity of being superior guardian for minors in the court too. So all those kids out there, you keep those kids in good shape, because I don't want to have to come over and take them over to my house for the weekend, all right? That's kind of the bonus. Any questions that we have? Yes, ma'am.
It's kind of a very specific question in my situation. Can a guardianship of person, how does that affect the person's employment?
If you're a guardian of a person, it for example, Bueller's. I'm just pulling an example out. Giant Eagle. I have an individual who's not capable of taking care of their affairs, i.e., cashing their paycheck and stuff. They can still work. You can be the guardian of them and their assets and have those items provided, and you're the person who would be placed in that role. I can see you have a follow-up for me.
Yeah, no, this is about signing employer paperwork.
For
Well, aside from assigning their application,
signing health insurance applications.
or he signed up for a retirement plan that I had no idea that he did.
You would have to go in as the guardian and establish that and do that. So you would, if you are the guardian of their estate, so you're just the guardian of the person. So you have to move to be the guardian of the individual's estate too. I had numerous individuals whom I was appointed to be a guardian for, who had retirement plans when I was in private practice. They may have had an incident later in their life after I know I had one gentleman who was at, the Chickmaster, and he had a pension and everything through Chickmaster and this retirement stuff, and it was the biggest problem because I became the guardian and I had to locate all these things. It wasn't provided to you necessarily all the time. It's like you're opening up sometimes like what am I getting myself into? That same individual had 24 motor vehicles that he had walked into and got conned out of by a junkyard. He had operational Jeeps. He had all this stuff that was of value. And I had to go back as the guardian, get permission, and sue to get those items back to expend on that person's behalf. Then I had to find out, I had to track all this information down as to, oh my gosh, this person was employed, had a history, had a policy for this, policy for that. I had to go meet with the employer and track all those things down. But you have if you're just for the person, it's just maintaining their well-being, a roof over their head. So you're not the guardian of their estate, so you can't deal with their financial affairs. Yes. She's got another question for me. Okay, sure.
So then the turn that retirement plan that he has into a stable account, which he can have, but he
Yes.
doesn't have a clue about any of that,
You need
we'd
to,
have to change our guardianship.
yes, you should petition to modify to a guardian over his estate as well. I would suggest you do that. And part of your basis would be that employed, he's elected for these things, and it could adversely affect benefits they're receiving. Court hears that, okay, we put you in that position. Then you can go back and negotiate with that employer and sit down with the HR department there and get those items squared around. Got a bunch online.
Yes. And I did just want to mention before I forget, we have regularly done a presentation on trust and estate planning, which is recorded and on the agency YouTube page. So if that's something you're looking for more information about, I know you've talked about that.
Sure.
That's available on the agency YouTube page right now. So the first question here is, in the case of divorced parents who don't get along, will the courts deny them being co-guardians? Can one parent block someone from being a co-guardian?
Typically, that's like a case-by-case scenario. And that's one of our concerns. Are you going to work for the best interest of the ward in this position or a person under guardianship? And we'll have those divorce cases spill over that I don't want this for Johnny or Janie or whomever. I've had situations where we've sometimes even ordered people to go out to mediation. Can we sit down and sit down with a neutral third party to figure out what's best? And sometimes that's the egos of the parents getting involved. If we find that neither are capable of doing the job, we'll appoint a third party, typically a counsel or an attorney. And we're also considering other options down the road to putting together potentially a guardianship board, but that is very, 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 very in the early planning stages. So.
Great. This one says, my 18-year-old daughter is living in a residential setting and receiving homemaker personal care services. She is unable to make decisions on her own. I am her representative payee. Do we need guardianship?
Well, I'm not going to tell you. That's one of those. Does being the residential payee, is that sufficient enough to resolve the issues that are going on in decision making that you have to make? I would think probably not. In the big scheme of things, you're better off coming to the court, getting the guardianship established, and it's not such an onerous task to be a guardian, to fill out the financial statements, the reports. Hey, this is being used for this purpose, and you'd also get the control also over an 18-year-old as a person to make sure that they don't make poor mistakes. One of the other things that is not talked about much, but if someone becomes married, if someone were to, this happened actually for an individual who was under guardianship in Medina County. He was living down the Burbank area, flexible with Wayne County, and this was several years ago. I think 2 judges ago. And a woman took him over, got a marriage license with him in Wayne County, and got married at the Wayne County Municipal Court. And no one checked back to see he was under guardianship in Medina, and marriage terminates a guardianship. You would think that the person's now no longer incompetent. You're supposed to come and ask and seek permission from the court as to whether or not this person should be allowed to marry or not. But it can terminate a guardianship, and that's what it did. And this person who had crafted this person out of it, the guardianship in Medina County, was doing it just to get to this person's monies. Sad, but there's people out there that do that. Yes, next one.
As a parent, can you be guardian to more than one child with a disability?
Yes, absolutely. The question was, can you be guardian to more than one individual in your house? Yes, it's not one guardian, one person. I was the guardian as an attorney for probably 12, 15 individuals at one time. And I fielded the calls and went out, and part of my obligation was to go out and see them on a regular basis, their condition, where they were. And we just had that kind of plotted into my family's agenda. My kids were little. My oldest is like 28 now, coming home tonight. But she remembers the days of us going out to Newbridge Place and other places. What are we doing? We're stopping to see Mr. Carl today. We're stopping to see this person. That just was part of our checkup on folks. Next question, please.
If the person is part of a trust, then will I need guardianship of the estate?
Well, it sounds to me, I'll try to discern this person's question a little bit better. Are they a beneficiary under the trust? I assume that's what they are meaning. Well, you need to be a guardianship over their estate? Yes. Because if a parent were to set up a trust for 5 children, one is at some point in time requires a guardian for them, you'll need that person to have a guardianship over their estate, unless their trust provisions are modifiable too. So it's not so they can bypass that individual, or if they're going to have to pay those monies out. We'll have hearings on those matters quite regularly in the court to determine what sums may come into that individual. Can they disclaim those funds so that it doesn't make them ineligible for other services? So if you run into something that causes you concern as a guardian or going through this process, it's best to bring that to the court's attention. You can file a motion if you have a case pending with an individual. Hey, I have a concern about this. We'll schedule usually for a status conference, try to figure out what the issue is, and then we will address that issue if we need to have a full hearing on it and give everybody notice and bring the ward in, etc., and all of that. Okay. Yes.
When it comes to a special needs trust and language that's in there that a parent or someone else has set up for an individual, how does guardianship interact with a special needs trust? Does one supersede the other or invalidate, or?
No, they work kind of hand in hand. If you have a special needs trust, the goal is to not modify and not screw up the provisions of that special needs trust. It dribbles out typically funding to support the ward, but not go crazy on the other end to vacate the terms and conditions for income IRS reasons and some other matters. So those two matters can work together quite well. And if you're the guardian of the person, you may not be named the trustee under the special needs trust, but it makes sense for a parent typically to be in both capacities, from my perspective. Yes, yes. And that's what that trust is set up there to do. And if you don't have a successor, and if, let's say, the entire bloodline of Kevin Dunn is gone, what would happen? Who would be my guardian when I need that? Who would take care of me? The court would step up. We'd find someone, appoint someone to be in that position, and we'd honor the terms and conditions of the special needs trust.
So if we have a successor trustee, we should also have them as a successor guardian. That would be.
You do not need to do that. That person could apply, or you could have the court. That person may not want to do that.
Okay.
Depending, you may want to have that discussion with them. They may petition the court if something happened to, let's say, both of you. Worst case scenario, you walked out here and the bus hit you in the parking lot. How would we fill those roles? And that would be part of the process we would go through. And if you couldn't fulfill those roles, the court would take efforts to locate an individual to be able to manage those matters for you. Sometimes that could be a volunteer guardian in some matters, depending how severe the situation is. If someone has all of their assets set up, paying for everything, and basically we just need to have someone come in and check out to make sure that their being fed, that their condition is fine at a facility, we can have a volunteer do that. We have some individuals willing to do that. If it's a financial matter, if it's complicated, oftentimes we'll seek out and we have a list of attorneys that will do that work at a much reduced rate that's paid for by court funds if the ward does not have funding to be able to assist in that. Another one?
No, somebody had just asked about a
Okay.
copy of the presentation,
Oh,
which
sure.
I will send out with a link to the recording as
And
well
it
as
sounds
an
like
event
you guys
survey.
are getting ready to apply. Okay, I'll give you, I only brought one of these, but you're welcome to pull these up off. It's 20 pages. It just kind of goes over some of the terminology and things like that. Things that you need to research your options. And absolutely, what's the role of the probate court? Besides being the heavy, sometimes we have to go out there and track people down. And oftentimes we have to ensure that people are being taken care of. Some situations, everyone's case is different, but we try to give a general overview. And each county handles these matters a little bit differently, but the process you have to go through is pretty much the same. So Summit County, Judge Stormer, Wayne County, Lorain County, and Cuyahoga County has 2 probate judges up there, Judge Russo and Judge Gallagher. So they're a little bit different up there. Anything else? Thank you so much. I really appreciate your time and allowing the court to come out here and present some stuff to you. And hopefully, if you have any questions or concerns, do not hesitate to reach out and send us an email or contact the court. Our staff is usually very helpful to provide that stuff for you and specific questions on a case. Give us a notice or a heads up. Write the court a letter. We can get the process going on our end to get things moving to make sure that the ward is being taken care of. Thank you so much. Appreciate it.
Okay, thank you. I got it.
I just mauled your thing. Someone want a copy of this? There's the presentation if you wanted it. The notes?
Yes,
You can
yep.
email it. But if you
Yep.
want this one, I'll give it away. Lucky winner.
All right, so again, big thank you to Judge Dunn for your time this evening. Thank you, everybody, for attending today, everybody who joined us online. Just a reminder, again, I will send out the presentation, and this will also come with a link to our presentation and event survey, so if you could just take a moment to fill that out, that's super helpful in the future planning of events and trainings. If there's something that you would like to see more information on, please include that on there. Okay, and then just a few upcoming events. Our ice cream social is next Thursday on the Medina Square. It will be here if in the case of inclement weather, 6 to 8 p.m. And we are also hosting an Achievement Center summer get together on Saturday, July 19th. That's from 4 to 7 p.m. here. We will have it out on our back patio and pavilion area in the gym in case of rain. We would like to, invite individuals back who have attended the Achievement Center, as well as anybody else receiving county board services who would like to attend with their support person, family provider. Please come out. The link to register is on our event page on our website. And I think that's all I have. So again, a big thank you to Judge Dunn. Be safe and have a great evening.